This rather nice building. This is our local Quaker meeting hall. Quakers, of course, are also the Society of Friends. So I thought this would be a good place to come and talk about friends in the law. So what is that? Well, I was going to talk about learned friends, McKenzie Friends and litigation friends. Learned friends, what's that? That's just a form of address we use, you know, my learned friend. That's what barristers call each other in court. When solicitors have higher rights of audience, which allows them to come into the same courts as us, we actually address them as my friend. We don't give them the learned, which to me is always seen a little bit sort of petty. The argument is, well, we do loads and years of training to do this, and they only do a short, like, couple of weeks course to get these higher rights. But when I did the litigation ticket, which allows me to do solicitor work, that was literally like, you know, a one-day course. So I'm not sure we're in the position to to get too fussy about that. I also, if I'm in the magistrate's court, I also like to address the legal advisor, the old court clerk as they were, as your learned legal advisor, because they're actually pretty learned in the law. They do know, you know, they advise the lay magistrates on the law, and they tend to be legally qualified anyway. Usually they're solicitors, but some are, you know, some are barristers. What about McKenzie Friend? They're actually now called defendants' assistants, although everybody actually still calls them McKenzie Friends. A McKenzie Friend is just somebody who goes along to court with you to, you know, give you a bit of a moral assistance. What are they allowed to do? They're allowed to sit next to you, they're allowed to quietly advise you, they're allowed to make a note of proceedings, and they can suggest things like cross-examination questions. What they're not allowed to do is actually have any conduct of the case, so they can't ask questions, they can't address the judge. Having said that, sometimes if a claimant or a defendant in a court case is actually really struggling and the McKenzie Friend is clearly helping and, you know, not trying to disrupt proceedings, judges will actually allow them to address the court, because a judge can grant rights of audience to anybody on an ad hoc basis. So sometimes that does happen. There is some controversy about McKenzie Friends. Now, don't get me wrong, a lot of McKenzie Friends are brilliant and they really help people out. And anybody can do this. You can, you know, it can be a friend or a family member. But there are professional McKenzie Friends. And they actually charge for their services. Now, some people have said, well, this is getting a bit dodgy because you're better off with professional legal representation rather than, you know, because you don't need any qualifications to be a McKenzie Friend and you don't need to carry insurance. But, you know, some people are finding that, especially, you know, with the cost of, you know, legal expenses, as a sort of reasonable thing to do. But there are some McKenzie Friends out there who, you know, are pushing an agenda. They, you know, they have a certain cause and they use people's cases to promote that. And there have been some quite horrendous incidences of, you know, McKenzie Friends just going out there and just ruining what might have actually been a good case just because they want to push an agenda. I mean, there can be a little bit of overlap with all the Freeman on the Land stuff there as well. But like I say, you know, a lot of McKenzie Friends are really, really helpful. What's a litigation friend? That's actually an official role. If a claimant does not have capacity, say they're a minor, or, you know, they're an adult but they just don't have capacity for either a permanent or temporary reason, like a disability, then a litigation friend is appointed to conduct the litigation on their behalf. They step into that person's shoes. You apply to the court. Again, it can be a friend or a family member. You can get, you know, like a professionally legally qualified person to step in. If nobody can be found, the official solicitor appoints somebody to be the litigation friend. But it's quite an onerous task. I mean, what is your responsibility? Your responsibility effectively is to, like, liaise with the solicitor. You don't have any conduct of the litigation itself. You can't actually get embroiled in the litigation. But what you can do is liaise with the solicitor, you know, liaise with the court if necessary, do all the things that the claimant would do themselves if they had the capacity. But when you agree to be a litigation friend, you give an undertaking that you will be responsible for any adverse costs. And there was quite a sad case recently where somebody had agreed to be a litigation friend for somebody, but they just found it overwhelming and they were having mental problems of their own and they just couldn't cope. Now, they did apply to come off as a litigation friend, because you can't just not turn up. But they didn't do that until after an aborted hearing. So what happened was there was a hearing listed for 5 days, and the litigation friend, they just didn't turn up and they didn't notify anybody, because, like I say, one of your responsibilities is you must attend every hearing. And because of that, the hearing had to be adjourned. So who pays the costs of that? Because the other side had turned up ready to rock and roll, and now that all those costs are wasted. Well, the court said the litigation friend had to pay it. That was £41,000. So, you know, this is not a task to take on lightly. Like I say, you can come off record either because you're finding it overwhelming, or just because there's no need for a litigation friend anymore. A child turns 18, well, they don't need a litigation friend. Or an adult who lacked capacity now has capacity. To come off record, though, you actually have to apply to the court, and you have to say why, and you have to show. So, if you were saying they now have capacity, you'd need sort of medical evidence to show that, in the same way that you would have needed medical evidence to come on record. But there you go. As always, hope you found that vaguely useful and vaguely interesting. I will do the please click like, subscribe, share, and apparently click the notification bell as well. I mean, like I say, I'm not bothered about that, but YouTube only seems to take you seriously and give you access to all their facilities if you actually do build subscribers. So there you go. Right, I'm going to get off now, because for once I'm not actually trespassing. I did ask if I could actually stand here, and Quakers are really lovely, but I am actually parked on parked next to a no parking sign. So I think I'll get a shift on before my luck runs out. See you next time.